Okay.
This is Dallas Marshall.
It's who?
Dallas Marshall.
Oh, Dallas Marshall. And who was the Nolly?
Duncan.
Is Duncan here?
Downstairs.
Oh, okay. Can we just have his attorney advise him what without prejudice means?
Did you already?
Or do you want him brought up? Mr. Duncan, do you need him brought up?
No, I mean, we're gonna do the Nolly, right?
Correct, but he needs to be advised that it's without prejudice.
Oh, yeah, that would be great then. Yes, please.
Okay,
Thank
we
you.
can bring him up. Let's wait a minute though. We'll do Marshall first.
It's Sarah's. She's talking. Like, busy.
No. We're on the record in the matter of the people of the state of Michigan versus Dallas Jack Marshall and file number 23-00480. Council appearance.
Brian Ring on behalf of the people.
An Assistant Public Defender Sarah Donnelly on behalf of the defendant Dallas Marshall, who is appearing in person and to my right.
How are you, Mr. Marshall?
Fine, Your Honor.
Okay, today was the date and the time that was set for a final pre-trial. Are we proceeding to trial on this?
You know, at this time, I would be asking for an adjournment, and I would be seeking to have the defendant remanded and bond changed to at least adding a GPS tether. There was an alleged incident back on the 27th of March where he potentially approached the household and broke into the house. There are further charges pending on that matter and potentially the PA-53 pending on that matter. I was just provided this police report not long ago. I mentioned it to Sarah this morning, but she has not, obviously has not seen a police report in that matter.
I have a copy of the police report here. Dated March 27, 2023. At approximately 0900 hours, officers allegedly were dispatched to 405 South Fairview in reference to a breaking and entering that allegedly occurred the night before, March 26th. And I think they provided some surveillance camera. You said there are pending charges as a result of this?
We haven't received the police report in our office yet
Okay.
in order to request anything.
Okay. Got it. Okay, so Mr. Marshall, you were arraigned back on February 10th at Magistrate Millmore, and you were advised at the time that you were not to have contact directly or indirectly with the Kelsey Napier. You were advised that you were not to be within 2,000 feet of where Kelsey Napier lived, worked, or goes to school. The allegation, as outlined in this police report, is that you violated the terms of your bond conditions testified being at the address of 405 South Fairview, which is the address in which the alleged victim lives. And so because of that, you will be remanded on a PA 53 violation, and a new bond will be set. The original bond was set at 300 personal recognizance.
I'm sorry, can you repeat that, Your Honor?
Your original bond was set at only 300 personal recognizance, meaning you were released, given an order, and the court believed that you would follow that order. Now there's an allegation that you did not do that. And based on this report, some video evidence to support the allegation. But you do have the right to have a contested hearing on these allegations, and you have the right to have the prosecution call witnesses or present evidence to support beyond a reasonable doubt whether or not you violated your bond conditions. Do you understand that? Okay, for the purposes of his arraignment, is he pleading not guilty?
Yes, Your Honor.
If you're found to be guilty, your bond can be revoked, sir. You can be sitting in jail pending this underlying incident. Do you understand that?
I do, Your Honor.
Once your plea of not guilty at this time, add to the PA 53. And then we want to reset the final pretrial, or do we have a witness here today?
I did not have a witness here today, Your Honor.
Okay. Why was there no witness here today?
I do not know. We had good contact with her up until she was here at the pretrial, the last pretrial. She was appeared by Zoom at the last pretrial, Your Honor, so she has since stopped returning calls.
Okay, we gotta reset the final pretrial and set the PA 53 hearing for the same date. Final pretrial, April 17th. April 17th at 8 o'clock in the morning. That'll be the same date and time set for the PA 53, okay?
Jury trial,
Yes, we can set the jury trial.
so it'll be May 1st.
Jury trial May 1st at 8 a.m. New bond will be set at 500 personal recognizance with GPS tether, victim notification. You're being remanded until the time that GPS tether is applied, okay?
I understand, Your Honor.
Not to be within 1,500 feet. Of Kelsey Napier. Do you understand that?
I understand, Your Honor.
Do you have any questions?
Do I pay the 500 on that right now, or?
It's personal recognizance, which is the same as your last.
I understand. Yes, Your Honor.
Okay. Any additional matters for the record today?
Nothing on behalf of the people. Thank you, Your Honor.
And no for defense, thank you, Your Honor.
You're all set, sir.
Name is Alan Calvin. ALN. I have about talking, I had said no changes. You don't understand.
You said Alan Pollock?
Yes.
Who's his attorney? Is that Mr. Donnelly?
I believe so.
Donald.
Okay. Dahlia, this is Mr. Pollak.
Hello, Mr. Polly.
Hello.
Good to see you. I will vote.
Mr. Austin, is Mr. Yazid in custody?
Mr. Polly, come on, stay here.
Yes, Your Honor, still in custody.
It's not easy to do.
I understand.
Oh, his attorney, his counsel, got it. He's at the jail, not downstairs. Let me see if I can get back to Zoom. Got it. Are we ready, Mr. Yazid?
I know.
Oh, boy, okay, so let's see what we can do. We're on the record in the matter, or matters, of the people of the state of Michigan versus Malik Yazid. I have file numbers 23-00084 and 23-00107. Council appearance.
Brian Ring on behalf of the people.
Yes, good morning, Your Honor. Jared Austin appearing on behalf of Mr. Yazid in file 23-107 FY. And if need be, I can fill in for Ms. Donnelly in the misdemeanor file.
Okay, sounds, today was the date and the time set for sentencing. Mr. Yazid, can you hear us?
Yes, I can hear you.
Okay, thank you. Let's see.
The same reaction.
It's, we're both laughing because
It's not good. Okay, how are we proceeding?
Well, Your Honor, I think at least on the misdemeanor case, Mr. Yazid can be sentenced. He's well served more than the 30 days on that. So we would ask for a sentence of time served on that. I think that would be appropriate, Your Honor. As it relates to the felony case, Your Honor, there seems to be some confusion. The last time we were in court on this, Your Honor, we attempted to do a plea taking on a misdemeanor of larceny less than $200. Attempted to do a no contest plea due to the statements and the conduct of Mr. Yazid. The court rejected that plea and stated that he should be remanded and be evaluated by CATS. But for whatever reason, it seems to have been set for a sentencing hearing. The ROA does not properly reflect what happened in court the last time, and there is no PSI as it relates to this matter. So if need be, Your Honor, I've spoken with Mr. Yazid. He is willing to go through with the no contest misdemeanor plea if the court would allow. If not, Your Honor, I would at least ask that the court consider releasing him on his own recognizance, given that he has served 84 days, I believe already, of what would be a 93-day misdemeanor that we attempted to do the plea taking on the last time.
Yeah, I don't know why this is set for a plea. My note is very clear.
I never
Had
received.
outbursts, appeared to lack understanding, and I ordered him to undergo evaluation at CATS, and he was remanded for that time. So we couldn't complete we could not complete a plea at that time. Additionally, the pre-sentence report would seem to reflect that even at that time, there were some concerns about his cognitive ability. I would not accept a plea from him without a evaluation from the forensics. I don't think that I'm able to.
And so instead of him being evaluated by CATS, which the court indicated the last time, at this point, the court is requiring that he undergo a forensic evaluation for competency from the forensic center.
Correct. The report from probation is that the defendant minimally completed the basic paperwork or checked every box in certain section that is unclear. If this was intentionally or if he just does not understand the questions. He was very distracted during the interview, often smirking or laughing. Numerous questions had to be asked several times. It is unclear if the defendant was not taking the interview seriously or if he's easily distracted. Mr. Yazid appears to be cognitively impaired and in need of ongoing mental health services. He appears to have no self-awareness that his actions were unacceptable. It does not seem to harm, he does not see the harm in his continued illegal behavior. So I do have a concern. Did I get an evaluation from CATS?
There does not appear to be one, Your Honor. I did speak with Mr. Yazid. He said he was seen by cats when he was in the old facility. He has not seen them since the transfer to the new facility. But if there was some type of evaluation or report done, I have not been made privy to that. I will note, Your Honor, I have represented Mr. Yazid on this file and on other files as well. I do agree that he does have some certainly a component of mental health and cognitive issues. That doesn't necessarily mean that he's not competent to proceed and move forward, but I do agree that he does have some of those issues that certainly do need to be addressed.
Ms. Donnelly is present. If you, Ms. Donnelly, we are on the record in the matter that I think you are representing him on the misdemeanor.
Yes, Your Honor.
Okay, and so the pre-sentence report really only applies as to case number ending in 0084, which is your matter, correct, Ms. Donnelly?
Yes, Your Honor.
Okay, for the purposes of that matter, we did enter the plea, it appears.
Yes, Your Honor. He pled guilty to trespassing.
Okay, so we will credit him time served on that. Close that file. So this one should not have been set for a sentence. It should be, probably was set for sentence, and then when the sentence or the plea failed, it was not properly reset. So on this matter, I don't see, and my note clearly states remanded for a CATS evaluation, but I don't see where one was done. Or I didn't get a report at least.
Or did I, if there was one there?
So the offer was for him to plead no contest with
Correct,
adding
Your Honor.
count 3 of larceny less than 200. I don't have a police report, but unless, I guess I do.
I'm sorry, Your Honor.
I do have one. I was looking for a police report.
I brought an extra copy if the court needed one.
Okay, and Mr. Yazid, did you hear everything that we said today?
Yes, I did.
Okay, so the people are offering for you to plead no contest to an added count 3 of larceny less than 200. That's a misdemeanor with a maximum penalty of 93 days in jail and or up to $500 in fines and or 3 times the amount stolen. Do you understand that?
Yes,
Okay, do you want to accept that offer today?
yes, no contest.
Okay, please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes,
Okay, you can put your hand down. What's going on with your shirt? Button it up, sir.
it's not buttoned. I asked him for one last night when suit changed and it doesn't button up for some reason. It's only the top one that buttons. And I've been asking for one, but they haven't gave me one.
So you need a new shirt?
Yeah,
Okay, we'll talk to the jail and see if they can get you a new shirt, okay?
okay.
Okay, so you have some rights, sir, in this matter before you can plead no contest. I need to make sure you understand your rights. You have the right in this matter to have a trial and you have the right to have a jury trial. Do you understand that?
Yes,
Okay, at the time of your jury trial, you have the right to the presumption of innocence. So do you understand that you are innocent until the prosecution can prove you guilty?
yes,
And they have to prove you guilty by proving each element of the charge being brought against you beyond a reasonable doubt at a trial. You understand that?
Yes,
You understand that in order to plead no contest, you would have to give up those rights.
yes,
Okay, you have the right to question or cross-examine any other witnesses that they intended to call against you. You want to give up that right,
No.
sir? You do not?
no. Wait, no, I wanna give it up, yes, I do, I wanna give it up,
Are you sure?
yes,
Okay. You also have the right to call your own witnesses to a trial or present some evidence that you believe would show that you're not guilty to this or that you had a valid defense. Do you understand that?
yes,
Okay, you want to give up that right?
yes,
You have the right, sir, to remain silent at a trial and not have silence be used to show that you're guilty. You understand that?
yes,
Okay, so that means you could come to trial, you don't have to say anything, and you don't have to put on any evidence. You want to give up that right?
yes,
Is anybody threatening you to get you to waive your rights?
no,
Has there been any promises made to you to get you to waive your rights?
no,
Do you understand that a no contest plea could result in a conviction that may impact your or have an effect on you getting a job, or you might have to report a conviction to a future employer?
yes,
And also a conviction could have impact on travel status or any immigration status you may be seeking. Do you understand that?
yes,
Are you currently on probation, parole, or serving time on another matter?
no,
Okay, at this time, I don't necessarily have a concern about his cognitive ability. So I would proceed with a no contest plea. And the purpose of the no contest plea was,
Connor, he had a lack of memory due to being under the influence as reflected in the report.
okay. Okay, and so, Mr. Yazid, as to the added count 3 of larceny less than 200, do you want to plead guilty, not guilty, stand mute, or no contest?
no contest, but I already plead guilty.
Well, not to this one. You pled guilty to a trespass. Do you remember that?
No, I could plead guilty to the trespass and the larceny, or, no, you dropped it to a misdemeanor, remember?
Correct. It's a misdemeanor larceny less than 200. You want to plead guilty?
Yes,
Okay, what did you do to make you guilty?
I took $10 out the tip jar next to the cash register.
Okay, and then where was this $10, where was this cash register? Was it at Grand Traverse Pie Company?
I said I took it out the tip jar next to the cash register.
Okay, was that at the Grand Traverse Pie Company restaurant?
Right downtown.
Okay, and that's in the city of Lansing?
Yes.
Okay,
Yeah.
Ingham County? Okay. Any additional questions?
Not from people, Your Honor.
Satisfied, Your Honor. Thank you.
Okay, I believe in no, not guilt, I mean, the guilty plea is satisfied and so is the factual basis. I'll accept your plea. I find your plea to be made freely, voluntarily, and intelligently. He was arraigned on this matter back on January 12th. Credit of time served. You're all set, sir.
Thank you.
You're welcome.
Yeah, that might take a lot of paperwork.
What happened to Mr. Duncan?
I have not seen Mr. Duncan.
I forgot. That's why I wanted you to wait. One trip.
Did forget.
Okay, sounds good. We'll bring him back. Are you ready, Mr. Pollock?
I am.
We're on the record.
Yes, you can walk up that.
We're on the record in the matter of the people of the state of Michigan versus Alan Pollock, file number 23-00600, council appearance.
Brian Ring on behalf of the people.
An assistant public defender, Sarah Donnelly, on behalf of the defendant, Alan Pollock, who is present and standing to my right.
How are you, Mr. Pollock?
So, dude, haven't been in court for a heck of a long time.
Oh, well, you're back,
Yeah, I've done it.
indeed. And you have one count of domestic violence here, sir. Was there an offer on this?
There was not, Your Honor.
Are we proceeding to final pretrial?
And jury trial, yes, Your Honor.
Final pretrial, April 24th.
Pretrial will be April 24th at 8 o'clock in the morning.
Trial, May 22nd.
Jury trial will be May 22nd at 8 a.m. Both of those are in person at the court, okay, sir?
Funny.
Both of them, you need to come in person to the court, okay?
Okay,
We'll get you a copy of your notice to appear. Do you have any questions?
no.
Okay, any additional matters for the record, counsel?
Nothing on behalf of the people. Thank you, Your Honor.
And no for defense, thank you.
Thank you. You're all set, sir.
And
LaDante Jones, is he in custody?
I do not believe he is in custody, Your Honor. Our notes indicate that he failed to appear on a felony file last week, and I have not had any success in trying to contact him.
He's highlighted on my list. But Bigelow does that when they're in custody.
Oh, okay.
Highlighted in pink specifically, that means in custody. Blue means fingerprints. And green means non-public. Yellow color code.
I like it.
Code blue.
Yeah,
Pretty helpful.
yeah, he's in Ingham County Jail.
Who's that?
So how long's he been there? Since March 28th. When did he find, when was he, was it a Dale case?
So we didn't, he's gonna, we'll see if we can, they can put him on. Well, no, we didn't have victim here, do
It's
we?
gonna be a nollie.
Okay. He's being held on this or something else?
I think he's being held probably for his bench warrant for failure to appear on the other case, but we're checking that right now.
Okay.
It was a free trial on March 21st, so yeah, he got arrested for that.
So he's been in custody. He was in custody during the last hearing?
No, he was in custody since, it says here Ingham County booked him in on the 28th, so last Tuesday, but he failed to appear for a pre-trial conference on the 21st.
Oh,
Which
which
would have
sounds
been
good.
yeah, a couple weeks, week before that.
Okay, we're nollying this MDOP though, correct?
That's correct, Judge.
I'm sorry, who's here?
Jen. One day.
It's April, time's flying. I got my bar results in April when I
Well,
took it.
It's going nice and slow. I don't know. It's going nice.
I know
and
they
slow.
did, I know they switched over to this.
It should be easier to grade. There's less
That's what I was
essays.
thinking, right?
I want to say I got mine in May.
That's what they're saying. They're saying May.
Tell them to speed it up. People got P numbers they need to get. Where are they up to? P9? Where are they?
I have no idea. I walked in yesterday and I asked Andrew to sign something. I was like, one of these days I'll be able to do this myself.
Yeah. What's her last name?
Lawton, Lawton.
Okay, so Mr. Pogue,
Yeah.
oh, let me find your file. here. On the record in the matter of the people of the state of Michigan versus Bernard Deshawn Pogue, file number 22 L 2678951. Mr. Pogue, today was the date set for a show cause. That is because you have owed $200 on this file and you've not paid. You pled guilty back on January. You said you'd pay by Friday. This had a show cause back in January. You said you paid by Friday back in February. And as a courtesy, when you didn't pay, I set it for another show cause versus bench warning you. What's going on?
Yeah, I thought you gave me a bench warrant, so that's why I ain't paid.
You said what?
I thought you gave me a bench warrant, so that's why I didn't pay it yet.
I didn't. That won't help you. If you get a bench warrant, you'll get arrested and you sit in jail for $200.
Okay. You act like
You
act like I ain't never had a warrant before though.
Okay, well, if that's what you want. If you don't want to pay it, we'll just issue a bench warrant. It's up to you.
Okay, you gotta pay it when I get around.
I never issued but I never issued a bench warrant on this. But I can.
Oh, I thought you did, so I didn't pay it.
What are you gonna do?
Shit, I'm trying to get around to it today.
Okay, well, you can pay it today or we'll issue a bench warrant. How about that?
All right, well, just do what you gotta do. If I can't get around to it today, I just can't get around to it today. You just gotta do what you gotta do.
Sounds good. You have a good one. You can't help ignorance, that's for sure. Is this Mr.
This is Mr. Duncan.
Duncan?
You want me to have that conversation with him about what?
Let's go on the record. We're on the record in the matter of the people of the state of Michigan versus Dashi Vermont Duncan, file number 22-02164. Council appearance? We don't have a prosecutor in here. Where did he go? Oh, okay. We'll wait. Why would you log in for a show cause? It's so weird. That's okay.
He thought he had a bench warrant.
Well, you
He
got
didn't
one
pay.
now, so don't worry.
Right.
I ain't gotta go back and forth with you. Over $200. Council appearance.
Brian Ring on behalf of the people.
Assistant Public Defender John Lee on behalf of Dashi Duncan, who is present in the courtroom and standing to my right.
Thank you. Mr. Duncan, how are you? Pretty good. Today was the date and time set for a final pretrial in a domestic violence. The people are moving to dismiss this without prejudice because the necessary witnesses failed to appear. And so they're also objecting to the destruction of your arrest records under Michigan Compile Law 764.26A. So your case will be dismissed today. They have the right to reissue it against you, okay? Do you have any questions? We'll get you a copy of the dismissal. Any additional matters for the record?
Nothing on behalf of the people. Thank you, Your Honor.
Nothing for the defense. Your Honor.
Thank you. Who's still doing April Fool's
She didn't hurt me
jokes?
get my
Come on,
daughter.
guys.
I told my daughter we were moving.
Trying.
Oh, dude, she almost cried.
Oh, my God.
Good job, Darren.
And then so she spent the rest of the day trying to get me.
Yeah, see,
That's Mr. Zarka.
yes, Your Honor.
Okay, we're on the record in the matter of the people of the state of Michigan versus James Anthony Zarka, file number 22-01659, SM, counsel appearance.
Brian Ring on behalf of the people.
An Assistant Public Defender Sarah Donnelly on behalf of the defendant James Zarka, who is appearing separately from the Ingham County Jail.
Can you hear us, Mr. Zarka?
Yes, Your Honor.
Very good. Today's the date and the time that's set for a pre-trial on a stolen property. I don't know why they always give me an echo in there. How are we proceeding?
Your Honor, at this time, I think one more adjournment is all that's gonna be necessary. There's been a global resolution. It seems like it's fairly certain to be put in place in circuit court relatively soon.
Oh,
I would request a bond change, Your Honor.
how much time are you looking for?
I would say 30 days would be sufficient, Judge.
May 2nd.
Okay, we'll reset it for May 22nd at 10 o'clock in the morning. Okay, his bond is, looks like, I can barely read this morning, 1,000 cash surety.
Yes, Your Honor, I would want it to not convert to a PR today, but convert when he gets released to treatment, so that he can still accrue credit, and we have to get those other bonds changed as well. But he has completed CATS programming in jail. He's been in significant, I think over 100 days at least.
Okay, I'll have that converted to PR when he's transferred to treatment. Where's he going to treatment?
We'll need the bonds changed so that he can get even screened. They need to know that they're ready to go to a bed before they'll even screen them nowadays. So we'll get those bonds changed, and he might, I think he'll even qualify for a transitional at this point. But we'll see.
Okay. Bond will be converted as such. Any additional matters on this file?
Nothing on behalf of the people. Thank you, Your Honor.
And none for defense, thank you.
Okay, you're all set, Mr. Zarka. Good luck to you. See you next month.
Thank you. Thank you.
No problem. Okay, Mr. Lee.
Have Mr. Naquan.
We're on the record in the matter of the people of the state of Michigan versus Yasir Muhammad Naquan, file number 23-00588 SM.
Brian Ring on behalf of the people.
Assistant Public Defender John Lee on behalf of Yasser Naquan, who is present standing to my right. Next to him is our interpreter.
I wasn't told that we needed an interpreter. Who ordered the interpreter?
Towards E. Yeah, it was-
Oh, it is on here. Bigelow didn't highlight the thing. That's what happened. Gotcha.
I came here last time on the 20th.
Interpreter is purple. Got it. Okay, can you raise your right hand? Interpreter, do you solemnly swear or affirm that you are interpreting the matter now before the court completely and accurately and not divulge confidential communication, so help you God?
Yes, I do.
Thank you. Let's see, could you spell your name for the record, Mr. Interpreter?
Edward, EDWARD, last name EID.
Okay, very good. Today's the date. Today's the date and time set for a pretrial. How are we proceeding?
There is no offer at this time, Your Honor. We're going to set the matter for a final retrial and trial.
We can do final pretrial, May 1st at 8 a.m.
May 1st at 8 a.m. for final pretrial.
And May 22nd for jury trial.
May 22nd at 8 a.m. for jury trial.
May 28th,
22nd.
يعني وعشرين خمسة كمان في المحاكمة قدام لجنة
Both in person at the court.
راح يكون لازم يكون موجود حاليا شخصيا.
Any questions?
أي سؤال؟
Okay. Thank you. We'll get you a copy of your notice to appear.
هلا في مباراة أو نسخة عن التطبيق وهذا على أساس معلومات وعرض أوقات.
The additional matters for the record, counsel.
Nothing on behalf of the people. Thank you, Your Honor.
Nothing for the defense, Your Honor.
Thank you. You're all set. Mr. Joliot.
Good morning, Judge.
Good morning. How are you?
I'm good.
Is that your client on the wound tech?
Yes, Your Honor.
Okay. Let's see. Mr. Cotto, can you unmute your device, please?
Yes, Your Honor. I apologize.
No problem. Thank you, ma'am.
Thank you, Judge.
Okay. Okay, Mr. Joliet, were you aware of a bond violation?
I wasn't, Judge.
Okay. Were you made aware of that?
I was not even good.
So that we had a bond violation that was sent to the judicial office back on 3/14. Looks like there's another bond violation that was sent on 3/23.
Those, should I speak or no?
You should not. Did these come to you next? Someone needs to forward them to their attorney.
No.
He said it was sent to judicial office. Is this what they need?
They probably put it in file.
Lord help us. They think sticking something in a file means sending it to us. Okay, let us get these scanned and sent to both you all so that you can advise your client before we proceed. We're off the record. Mr. Watkins, who represents Mr. Watkins? Is that Ms. Donnelly or Mr. Lee?
I actually don't know that one, Judge.
Okay, Ms. Donnelly, I think is on Zoom. Mr. Blackman, how are you?
Oh, here.
Sorry,
Is SI city?
that's the one Mr. Blackman's on.
Yeah, that formal
I think
hearing.
that's statute.
I don't have it. I don't even have a file.
No statute infraction.
Delapez.
Oh, yeah.
I don't have a file. I don't have that file. What a crap me.
Judge, you know what might have happened? I had notice for tomorrow, the city attorney. My client called me and said, he got notice in the mail for today. And
Oh,
then
I
looked
have it.
up, and it said,
It's careless driving. That should be a city case.
Yeah, I don't have anything in my system at all.
Is your client already here?
He's coming in.
The city can decide if they're gonna give an offer by now. I mean, when I was at the city attorney's office, they called me upstairs all the time.
Judge, shall I just, maybe just call them or get hold of them later today and just try to take, because I have a freedom that's continuing. 55th.
I was gonna say, we could see if we can get a city attorney to come handle this right now. There was one was across the hall today.
What is his, email, Jolia?
Mr. Joliet, can you give us your email?
Yes, Your
Yeah,
Honor.
because they
I'm
have a city
sorry.
attorney over there.
It's my name, Your Honor. It's Michael T. Joliet at gmail.com. Michael T. Joliet at gmail.com. I'm sorry.
Thank you.
So
I didn't know that. Let me,
there's a bit of a sense of urgency.
yep, let me.
On whom? You here for Watkins as well?
I'm sorry.
Do you represent Mr. Watkins?
No, why?
There's Mason Watkins.
Oh,
on
I'm
it.
sorry, no, Your Honor, I didn't.
Oh, okay, well then we are waiting for Miss Donnelly.
Yes, Ms. Donnelly represents Mr. Watt.
Thank you.
I didn't think that was me.
Okay.
Yeah, I mean. If I was allowed to, I'd get you an offer right now, we'd be done.
I was gonna say.
He said Michael Doty.
Huh?
He said Michael Doty.
Is it Michael T or just Michael T Joliet?
Michael T. Joliet.
T dot.
Oh, okay.
What's the matter, man? What's your name?
Angela?
Yes.
Yeah, I'll talk to you in a second, sorry. I was just trying to look up to see what I had in my system really quick.
It was Angela who?
It's a victim on.
Oh, okay, sounds good. Yep.
Looks like we're ready here to go. Just hang tight. I'll be in a second, okay? Yeah. Yep. Okay.
Did it go through the email?
I sent it, so I just need to know if we got it.
Sounds good. Mr. Joliet, did you receive it?
No.
Oh, you're muted.
Oh, yeah, me too.
I did, Judge.
Okay, I can put you and Mr. Cottle in a private meeting room if you'd like to discuss it before we go back on the record.
That'd be great. Thank you, Judge.
No problem. Okay, who do we have here?
Karate.
Mr. Karatni, are we ready?
Yes, Your Honor.
We're on the record in the matter of the people of the state of Michigan versus Brett James Karatni, file number 22-03378. Council appearance.
Brian Ring on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant, Brett Rodney, who is present and standing to my right.
Okay, sounds like today we have two matters. Okay, it's a plea and a PA 53 violation set for today.
Yes, Your Honor. It was previously set for a plea before Mr. Karatny had medical issues, failed to appear, and had a bench warrant. At this time, there is a new felony charge in the preliminary exam on Thursday. There might also be added charges to that felony count. So at this time, we would just be requesting adjournment to see what will happen on that date, at least.
Oh.
Being treated as a PCC too, just there's full awareness that was being treated as PCC because he was going to hire his own attorney.
Okay, so whatever set as an exam is being treated as a PCC.
That's correct, Judge.
So we need to this week. So this week, so how long? His PC, so his exam day was this week? Yeah. Okay, so go 2 weeks out, or 3 weeks out, I should say. Did you find an attorney?
I was still waiting. My fiance is sick. She has cancer. She's in the hospital. I'm just waiting for her to get well enough to be able to do the funding. So I found one. I'm just waiting for her to be able to do it. So I mean, she's been out of surgery for almost 2 weeks. She's now into oncology, so she should be well enough to move money around.
Okay.
Hopefully in the next week or so.
Okay, because I was gonna say, when you said she was sick with cancer, I don't know what her health is, but it didn't make me feel comfortable that you're waiting for someone with cancer to get well enough.
No, she's
Before you get your legal counsel.
And she's on the
Okay, so she had surgery, she
Yes,
should
ma'am.
be on the
She had ovarian
mend.
cancer, she had it removed, she had a couple complications, and now she's on oncology and going through chemo, and she's on the mend.
Okay, so it's not likely that at your later court date this week that you'll have counsel yet.
No, ma'am.
Okay,
That's when I spoke to you Friday. I've spoke to her mom. She, like I said, she's doing much better. Like she had several complications. But
Okay.
She is doing better.
who was assigned to represent among the felony?
Austin.
Austin, okay, that's what, okay, sounds good. May 1st. We'll set this one for May 1st, 9:30. At 9:30. Do you have any questions today, Mr. Karani?
No, Your Honor.
Any additional matters on the record, council?
Nothing about the people. Thank you.
No defense, thank you.
Thank you. We'll get you a copy of your notice to appear. I'm sorry? Did you, I was gonna say, you didn't speak to Watkins yet?
I have spoken. I'm ready to, just in a second. Your Honor.
Okay, did we get his fingerprints?
I believe he did. He said he got them.
That's fine. Yeah, that's absolutely, that's fine with me. Does you want to proceed on walk-ins right now? Or do I have a second to go speak to it?
I'm ready to go.
Ready on Watkins? Okay. We're on the record in the matter of the people of the state of Michigan versus Mason Wayne Watkins, file number 23-00304 SM appearance, please.
Brandon Ring on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of defendant Mason Watkins, appearing separately by Zoom.
Okay, today was the date that was set for a plea. No, we did get a sticker. Okay. How are we proceeding?
Your Honor, at this time, it's my understanding that we still don't have contact with the alleged victim on a restitution amount. At this time, I would request, and there's no objection from the prosecutor, that we set this for a final pre-trial and jury trial. See if she appears.
Final pre-trial will be May 1st. And jury trial, May 22nd.
Final pre-trial will be May 1st at 8 o'clock in the morning in person at the court. If this proceeds to jury trial, we're scheduling it for May 22nd at 8 o'clock, also in person at the court. Do you have any questions, Mr. Watkins?
Mr. Watkins, can you hear us? You're muted.
Has he been doing something to his phone?
Almost like it's like, what are you doing to your phone? I've been seeing your sunglasses. I'll call him, Your Honor.
Can you hear us?
Can you all hear me?
We can hear you. Can you hear us?
Yeah. Is he good to go, Your Honor?
He's good. He's messaging us that he can't hear anyone.
Okay, I'm gonna call him.
Okay, sounds good. Okay, did we find a city attorney? No,
No, he, it's, Matt
Staples.
yeah, he's remote, so I'm sending him an email right now.
Okay, sounds good. If not, we can just reset this for another day for you, sir.
Oh, I can hear
I
now.
don't know, but. Oh, no. Did your attorney call you?
Yeah, but now I can hear you guys. That was weird.
Okay, yeah, I'm not sure what's going on. We set your matter for a final pretrial, okay?
Okay.
It's gonna be May 1st at 8 o'clock in the morning in person at the court, and then jury trial, May 22nd, 8 o'clock in person at the court, okay?
Okay.
You're all set, sir.
All right.
And then let's see. We're waiting for this to. Can I take that file back? The coddle? We have it. Right here.
So
What's Bush ready?
I asked about, because the city attorney sent an
He didn't
email
leave me a
about
voice
the Della Pass whatever. And I asked Susie, and she said that it should have been on our state.
Yeah.
Why is it on a, why would the state do this?
Because it was scheduled for, yes, I mean, tomorrow, but they sent an email. So I asked Susie, and she said.
We'll find out. So let's just look into this. This is not a city one. This is this should be today
Oh, it is.
because it was a state trooper, they said.
Oh, okay.
So, Mr. Ring, this is yours.
Oh, good.
I just, okay.
I don't even have a file or a ticket or anything to go off of. Thank you, Judge. Whatever's more palatable.
She actually told me thank you.
Whatever's more palatable.
Okay.
Yeah, all right.
Feel like it should be done. Should I bring him in, Your Honor? We have a deal.
Sounds good.
Thanks, bro.
Yeah. No worries.
Okay. Did I bring this to follow that? We're on the record in the matter of the people of the state of Michigan versus Jose De La Paz, file number 23417511821 SI. Appearances for the record, please.
Brian Ring on behalf of the people.
Your Honor, Fred Blackman on behalf of Mr. Delapaz, and he's sitting here right at the podium.
Thank you. How are you, Mr. De La Paz? I said, how are you?
All good.
Today was the date and time set for a formal hearing. How are we proceeding?
At this time, the people were offering a speeding 1 to 5 over.
Can I have a,
I was looking that up right now, Judge.
yeah, I'm gonna ask him for that. And he wants to accept that.
He would be responsible for that, Judge.
Okay, your fine is $130. When can you pay that, sir?
I get paid on Wednesday. Friday. Oh, judges, open Friday.
It's not, it's Good Friday.
Can I pay it online or I gotta come up there and pay it?
You can pay it online.
Okay.
You
Whatever
want-
fastest so I can get it paid out.
Okay, I'll know here you'll have it paid by Monday, okay?
Okay, thank you.
No problem. Speedy, you don't know what the speed was.
I don't know what the speed was.
Okay, well. 45 and a 50 today, okay? I mean, 45 and a 40 for the purposes of this plea, so we can move on. Any additional matters for the record?
Nothing for the people, thank you, Your Honor.
You're all set.
Melody,
Thank you.
257,
Does he need
627.
anything, do you need to give him, or is he good just to pay it? And I'm line with,
I'm sorry?
I just wondered if he got anything, or I should tell him to get online just when he.
Yeah, he would just get online and he would pay using this site, the case number.
Case number?
Yep, yep.
Okay, thank you. All right.
You're welcome.
Thank you.
Yeah, that's right. No worries. Wasn't even on my radar this morning. Nice. Speed radar.
Okay, we ready on Cottle? You got the email we sent, correct?
I did, Judge. Julia sent me a separate email, which I responded to. So. John there.
Okay, we're back on the record of the matter of the people of the state of Michigan versus Nicholas Cottle, phone number 22-03366. And today was the date set for a plea, I believe, but then we have the matter of potential bond violations. So the bond violation, I believe that I see here. Like he was arraigned by Magistrate Milmore and that she ordered him to have random preliminary breath tests 1 time weekly and twice monthly random urinalysis. Bond violation for a collection date of March 2nd indicates positive for cannabinoids. Then there is an allegation that he refused testing on the 22nd of March. And so, Mr. Carl, you have the right to have a contested hearing on these bond violations. You have the right to have the prosecution bring evidence to support the allegation that you violated your bond conditions. You understand that?
Yes, ma'am.
And a violation of your bond condition, it can be punishable as a contempt of court, maximum penalty 93 days in jail or up to $7,000 in fines. You understand that?
Yes, Your Honor.
Okay. How does he want to address the bond violations? Counsel.
Judge, this was this was actually set for a pretrial conference today. And we just learned of the bond violations. I had a chance to discuss the allegations of the bond violations in the breakout room with my client. It appears the first violation happened the first or second day after he was arraigned. And the other one was on a date where he thought he was doing a breathalyzer, was unable to produce a sufficient sample. And the prosecutor and I have reviewed the facts of the case, primary case, and entered into, or we've reached an agreement as to a plea. And I'd suggest that in exchange for the plea, that the bond violations not be pursued. If that's agreeable to the court and the prosecutor.
The note on the bond violation for the 22nd says he refused low temperature below 85 degrees.
I noted that and discussed that with my client, and he said he was unable to produce a sufficient sample.
Okay.
But it looked like all the other testing, and I don't know how frequent it was between the first date and that date, was all negative.
Okay, offer, if that is an offer, from the people as for the defendant to plead guilty as charged and that there's a sentencing agreement of no upfront jail.
That's correct, Your Honor. And I have discussed that with my client, and he's willing to go forward and enter his plea today.
Okay, and you want to accept that, officer?
Nick?
Yes.
Cottle?
Yes, ma'am.
Okay,
Yes, Your Honor.
You want to plead guilty to the charge of operating while intoxicated?
Yes, Your Honor.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes, I do.
Thank you. You can put your hand down. Okay, Mr. Cottle, you have the right in this matter to proceed to a jury trial. At the time of jury trial, you have the right to the presumption of innocence. So you're innocent until the people can prove you guilty. You have the right to have them prove your guilt beyond a reasonable doubt.
I understand.
Trial. Do you understand that?
Yes, Your Honor.
You want to give up that right today?
Yes, I do.
Okay, so that means you're also giving up your right to question or cross-examine any of the witnesses that they intended to call. You're giving up your right to call your own witnesses or present evidence at trial that you believe would further a defense to the charge. You're gonna give up your right to remain silent at trial and not have silence be used against you. You understand that?
Yes, I do.
Is anyone making any promises or threats to you to make you want to waive your rights and plead guilty today?
No, Your Honor.
You understand that a guilty plea can result in a conviction that you may need to report to your current employer, or you may need to place that you have a conviction on a future job application.
Yes.
With that understanding, you still want to waive your rights and plead guilty?
Yes, ma'am, I do.
Are you currently on probation, parole, or out on bond in any other matter?
Yes, I'm out on bond.
Okay. And do you understand that a guilty plea, or have you discussed whether or not this guilty plea could have an impact on your bond status?
Yes, I understand.
Okay. And a guilty plea could also have an impact on any immigration or travel status you may be seeking, like you may want to travel and visit Canada, and this could impact that. You understand that?
Yes, I do.
Okay. As to the charge of operating while intoxicated, how do you plead, sir?
Guilty.
Counsel, can you give me a factual basis?
Hello?
Nick,
Yes.
on June 24th, 2022, were you driving a car in Lansing, Michigan?
Yes.
And were you involved in a motor vehicle accident?
Yes.
Did you recall having a seizure?
I don't recall having the seizure, but I was made aware of it upon being in the hospital.
Okay. And after you came in contact with the police, did you consent to a blood draw?
Yes.
And we've agreed to stipulate to the admission of the laboratory reports confirming the presence of THC and fentanyl in your blood at the time that you were tested. Is that correct?
Yeah.
I have no other questions, Judge, and I believe this satisfies the factual basis.
Okay, do you recall what street you were on when you were driving on that date?
I do not. I'm not familiar all that well with the names of the streets. I apologize.
Mr. Caudle, if the police report indicated South Cedar Street at East Kavanaugh Street, you'd have no reason to dispute that, would you?
No, I would not.
Any questions?
No, that's satisfied.
Okay, the court is satisfied with the factual basis. I'll accept your plea. Find your plea to be made freely, voluntarily, and intelligently. This matter will be set for sentencing. Your sentencing date's gonna be May 22nd at 8:30, if that works for you, Mr. Juliet.
It does. Thank you, Judge.
Okay, prior to sentencing, Mr. Cottle, you need to report to our probation department because you need to have a substance abuse assessment completed if you have not already done so. And they need to provide me with a recommendation as to how you are to be sentenced. But I advise you that there is a Killebrew agreement of no upfront jail, but that agreement is between you and the prosecutor. I am not a party to that agreement. So if at the time of your sentencing, I decide that I'm going to deviate from that and sentence you, I would then give you an opportunity to withdraw the plea that you just entered, okay?
Yes, Your Honor.
Okay, so you need to report to our probation department no later than Wednesday at 10:29, okay?
Okay. That will,
And then
that'll
they'll
work,
set
Your
you
Honor.
up, they'll give you a questionnaire to complete and set you up for an interview. So you're gonna report in person. They'll get you all set up for your interview and they'll give you a new date for you to return for the interview. You need to make sure you complete all of that before your sentencing date, okay?
Okay, and that is this Wednesday you're speaking of, correct?
This Wednesday by 10:30, you need to have met with our probation department, okay?
Yes, Your Honor.
Do you have any questions at this time?
No, I do not.
I'm going to dismiss the violations, the bond violations at this time.
Thank you, Judge.
No
Thank you.
problem. Any additional matters for the record?
Nothing on behalf of the people. Thank you, Your Honor.
Nothing on behalf of defendant. Thank you, Judge.
Thank you. We'll see you on May 22nd, sir.
Thank you.
Thank you.
Thank you. Lydia Cotner is here, and did you have somebody else? Yeah, I see you have a victim.
I do. John and I are discussing that right now, Judge.
Okay, I'll let you handle that.
I have Mr. Bushray as well.
You need to speak to him?
No, I'm ready to go on both of them. Just wanted to tell you, or basically ask you about, he's having a complication at work this week. He was supposed to have today off, and they switched that on him, and he's gonna have to work all throughout the week. So he wanted to plead today, but with reporting to probation, he was a little worried. I don't know so we didn't want to court. Did you want him to plead today and hopefully maybe have him go to probation next week? Because like you said, he can't go to probation.
He can't go to probation at all this week, you mean?
Yeah.
We can reset it and then he can plead next week.
Yeah, he can plead it. Okay.
That's Bushray.
Yes.
We can do it on Monday. I'm just working. Oh. We getting benches in here. April
Yeah.
10 at 9. April 10th at 9:30. Mr. Bushray, we're resetting you to April 10th at 9:30, okay? You're muted, but I think you said thank you.
Thank you.
All right, have a good one.
Okay, you too. Bye.
We're on the record in the matter of the people of the state of Michigan versus Lydia Marie Cotner, file number 19-03271. Appearance, please.
Brian Ring on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of defendant Lydia Cotner, who is appearing separately by video.
Okay, Ms. Cotner, you can hear us, correct?
Yes, I can.
Very good. Today was the date and time that was set for a pre-trial on a retail fraud. How are we proceeding?
Your Honor, at this time, Ms. Cotner will be accepting an offer where she plead guilty to an added count of attempted retail fraud in the third. There is no need for restitution, and the state will dismiss the first count.
Okay. You want to accept that offer, Ms. Cotner?
Yes.
Please raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes.
Thank you. You can put your hand down. Okay, Ms. Cotner, in this matter, you have the right to proceed to a trial. You have the right to a jury trial. At the time of trial, you have the right to the presumption of innocence. So you are innocent until the prosecution can prove you guilty. You have the right to have the prosecution bring sufficient evidence to prove each of the elements of the charge being brought against you beyond a reasonable doubt at trial. You have the right to question or cross-examine any of the witnesses the prosecution intends to call. You have the right to call your own witnesses at a trial or present evidence that you believe will show that you're not guilty or that you had a defense to the charge. You want to give up all of those rights, ma'am?
Yes.
Okay, so you also have the right to remain silent at trial and not have silence be used against you. You want to give up that right as well?
Yes.
Has anybody threatened you in any way to get you to want to waive your rights and enter a plea?
No.
Has there been any promises made to you that's not stated here on the record for you to plead guilty?
No.
Are you currently on probation, parole, or serving a sentence on another matter?
No.
You understand that a guilty plea could result in a conviction that you may need to report to your current employer, or you may need to report a conviction on a future job application.
Yes, I understand.
Okay. A guilty plea could also result in having an impact on any travel or immigration status you may be seeking. You understand that?
Yes.
As to the added count 1 of attempted retail fraud, 3rd degree, how do you plead?
Guilty.
Okay, tell me what you did to make you guilty.
I did attempt to walk out of Meyer without purchasing the items. There's
Okay. Do you
no
remember
two
what
ways.
items they were?
Due to the fact
what the
that it
items
was so long ago, I know that it was I believe it was like an item of clothing and a few things of makeup, but I don't exactly remember because it was so long ago.
I got it. And so was the date of the offense back on October 15th, 2018?
Yes.
Okay, and was that at 6200 South Pennsylvania?
Yes.
City of Lansing, Ingham County, State of Michigan?
Yes.
And was the value of the clothing items and makeup less than $200?
Yes.
Any additional factual basis?
Nothing on behalf of people, thank you, Your Honor.
No, for defense, thank you, Your Honor.
Actually, and was that the Meyer in South
Yes.
Pennsylvania? Okay, it was open to the public at the time?
Yes.
Okay, the court is satisfied with the factual basis. I'll accept your plea if your plea be made freely, voluntarily, and intelligently. And you said there was no restitution.
No, all the product was returned to the shelf.
The fine is $125. When can you make payment?
Your Honor, one thing I do believe, Ms. Cotner, did you have a bond posted in this?
Yes.
Was it $30?
I 300.
300, okay, because it said 10%.
Let me see here. Was that in your name?
Yes.
Why did she post the cash bond in this? Apply the bond and you'll get the balance sent to the address we have on file. That address still valid on Perry Street?
Yes.
Okay, very good. Any additional matters for the record, counsel?
Nothing on behalf of the people. Thank you, Your Honor.
Enough for defense. Thank you, Your Honor.
You're all set, ma'am.
All right, thank you.
You're welcome. We're ready on fellas next. Um, Okay, we're on the record in the matter of the people of the state of Michigan versus Mark John Prelaznik, file number 23-00918. Council appearance.
Brian Ring on behalf of the people.
Assistant Public Defender John Lee on behalf of Mr. Mark Lesnick, who is with us in the courtroom standing to my left.
Good. Change the date and time set for pre-trial and have one count of domestic violence. How are we proceeding?
Your Honor, the prosecutor has offered us an amended charge of disturbing the peace, and we are set to plead to that charge today.
And that there would be a sentencing recommendation of fines and costs.
Okay, you want to accept the offer to plead to an added count 2 of disturbing the peace?
Yes, ma'am.
You raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Ma'am, is everything okay? Okay, you can have a seat. I have an advice of rights of the information sheet with today's date on it. Is this your signature?
Yes, ma'am.
Did you read this document?
Yes, ma'am.
You understand the rights listed here?
I do, ma'am.
Do you have any questions about these rights?
No, ma'am.
You want to give up all of these rights in order to plead guilty?
Yes, ma'am.
I want to criminal history. So you understand that you have the right to the presumption of innocence?
Yes, ma'am.
You have the right to have a jury trial.
Yes, ma'am.
You understand the time of trial, you have the right to be presumed innocent until the prosecution can prove you guilty beyond a reasonable doubt.
Yes, ma'am.
You want to give up that right?
Yes, ma'am.
You want to give up your right to question any other witnesses they intend to call?
Yes, ma'am.
You want to give up the right to call your own witnesses or present evidence that you believe would show a defense to the charge?
Yes, Your Honor.
Okay, anybody threatening you to get you to plead guilty?
No, ma'am.
You understand you're going to give up your right to remain silent at trial, not have silence be used against you?
Yes, ma'am.
Okay, any promises being made to you in order for you to plead guilty?
None, Your Honor.
Are you currently on probation or parole?
I am not, Your Honor.
Okay. Are you serving any sentence on any other matter?
No, ma'am.
Okay. You understand that a guilty plea could result in a conviction that you may need to report to your job?
Yes, ma'am.
It also can result in a conviction that you may need to put on a future job application, or it could have impact on immigration or travel status you may be seeking.
I do, Your Honor.
There's a sentencing recommendation. I'm not agreeing that I'm going to sentence you to fines and costs, okay?
Yes, ma'am.
You understand that?
Yes, ma'am.
As to the added count 2 of disturbing the peace under MCL 750.170, maximum penalty 90 days and or $500 in fines. How do you plead, sir?
I plead guilty, Your Honor.
On a factual basis.
Yes, Your Honor. Mr. Prolesnik, on March 18th, 2023, were you at the address of 4516 Star City in Lansing, Michigan?
Yes, ma'am. Oh, yes, sir.
And that is in the county of Ingham in the state of Michigan, correct?
Correct.
Okay. And at that time, you were having an argument with your wife, Angela Prolesnik, correct?
Correct.
And some point during that argument, she walked out to her truck and got in her truck outside, correct?
Correct.
And you walked outside after her and were yelling and otherwise being boisterous outside in the street, correct?
Very correct.
No further questions, Your Honor.
Any additional matters?
None from the people. Thank you, Your Honor.
Court is satisfied with the factual basis. I'll accept your plea. I find your plea to be made freely, voluntarily, and intelligently. Mr. Lee, you can address the court prior to sentencing.
Thank you, Your Honor. Mr. Prolesnik is a CPS worker with over 20 years of experience working, was a CPS worker with over 20 years of experience working here in the Ingham County area. He is currently looking for a job, and in fact has a couple of solid leads that he would like to follow up on so that he can get back to work. His service and dedication to family and the home structure speaks to his interest in these matters, as he has expressed a deep regret to myself, and would like to resolve this today and start having living a life that is healthy, that he advocates for on a regular basis.
Does your client want to make a statement?
Would you like to make a statement?
I left CPS after 25 years, serving families, have some PTSD, but I will tell the court, since the incident, I've been going to 12-step meetings most days, twice a day, because I can't. I've had some stumbling blocks getting jobs because when they do the background check, the original charge appears. I think I have verbally harmed my wife and my family, and I'm committed to doing the right thing. No matter what the result is, I enjoy my 12 steps. I've made a connection. My wife works for Dean Transportation, and once I'm home, I will be eligible for outpatient counseling, which I desperately need from what I believe is PTSD from, I just couldn't see one more. I don't want, didn't want to see one more hurt kid in a broken system, and I had to get out. I suffered some medical issues, and I'm ready to just move on and repair my relationship. Luckily, the counseling I'm offered at some point will offer my wife and I to work together. I believe, I can't speak for my wife, but I believe she is committed to restoring her family. And this was the worst thing I did. Didn't want to adjourn it or anything, because I also need to take some personal responsibility, not just for me, but for my family. I can't just shoot this under a rug. Messed up bad, really bad. Can't believe by the grace of God, my family's sticking with me. They don't have to. definitely gonna be consequences, and I'm just ready to basically take my punishment and hopefully move on and gain some employment. Looking to work with the homeless, that's kind of my passion. And hopefully this, if the disturbing of peace is accepted, hopefully that won't be a huge stumbling block. I'm just gonna have to be honest. And that's all I have. Thank you for letting me talk about it.
No problem. Are you already in counseling, sir?
I won't be able to get into counseling until I go home, until I'm eligible, because my wife has to make those arrangements. And currently, there's a no contact order, and I didn't know what. And that's the last thing I wanted to do, was mess that up.
Thank you. The victim, you can make a statement.
Yes, she would like to, Your Honor.
Okay, we just need her to come around so the volume can pick her up.
Want to hear Judge, or was over by me fine?
Over by you is fine. State your name for the record, please.
My name is Angela Jean Prosnick.
Okay, you can make your statement, ma'am.
And Judge, I am really hoping that my husband can come home. We can rebuild our family, rebuild our relationship. I have no fear that he's gonna try to do anything, in a negative way. I want my husband back. And from what I understand, he's going to a 12-step program. That is very good, and I will be doing anything that I can to help him, maintain that.
Okay, I've reviewed his prior criminal history. He didn't have anything. This is his first engagement with the criminal justice system on this side, it looks like. It's unfortunate, but it looks like you're on the right track. You're already getting some treatment. And you recognize, I guess, what your limitations or your concerns are going forward. Hopefully you'll get into the treatment that you need as it relates to counseling. You, at this point, pled guilty to disturbing the peace. The court's not going to order any additional oversight at this time. Sentence will be $300 fine plus $75 crime victim rights plus $50 state minimum cost for a total of $425. And you can make payments on that. How do you intend to get that resolved?
I'm gonna need some time. I hope to have a job in the next 2 weeks. And then, of course, there's always the week and a half or so before the first paycheck. I have some equity, some instruments and things that I'm planning on taking advantage of, I guess, to try to get some liquid money. I don't know if I'll make them. But I am going to need some time. I have every intention of making this a priority. Fortunately, my wife's the only income at Dean Transportation, which is less than a full-time job. Before this happened, robbing Peter to pay Paul for the basic bills. So
we're going to set, I'm going to give you 60 days at this point. If you are coming upon the 60 days and you've not had that paid, you're going to need to contact the court so that we can extend it for you, okay?
Thank you very much. I appreciate that.
No problem. Any additional matters for the record?
Your Honor, just for clarification, does that mean the no contact order will also be lifted today?
The no contact order is lifted. Thank you. Any additional matters?
Nothing further.
Thank you. You're all set. Anybody heard from Laura Morales?
I have, Your Honor. She was having trouble getting a ride this morning, but if you would allow, she can appear this afternoon.
Well, she had trouble last week too, so.
Yes.
We don't just get to pick the times we want to come to court. Especially when it's via Zoom. Okay, that's all we have until 1:30. Can I write what? Well, it doesn't continue unless I put that they continue, because he's no longer on bond. A plea is entered. That was a bond condition.
It is warm in